Chapter 28, Embezzlement. Section 505. Definition. Embezzlement is the wrongful appropriation, animo furandi, of the personal property of another by one to whom the possession has been entrusted by the owner. The gist of the offence is breach of trust. Section 506. A statutory offence. Embezzlement is not a crime at common law. The original English statute making this offence a crime was passed the last year of the 18th century. This statute provides as follows: whereas, bankers, merchants and others, are, in the course of their dealings and transactions, frequently obliged to entrust their servants, clerks, and persons employed by them in the like capacity, with receiving, paying, negotiating, exchanging or transferring, money, goods, bonds, bills, notes, bankers' melts and other valuable effects and securities, and, where hither doubts have been entertained whether the embezzling of the same by such servants, clerks and others, so employed by their masters, amounts to felony by the law of England, and it is expedient that such offences should be punished in the same manner in both parts of the United Kingdom. Be it enacted and declared by the King's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal, and Commons, in this present Parliament assembled, and by the authority of the same, that if any servant or clerk, or any person employed for the purpose in the capacity of a servant or clerk, to any person or persons whomsoever, or to any body corporate or politic, shall, by virtue of such employment, receive or take into his possession any money, goods, bond, bill, note, banker's draft, or other valuable security, or effects, for or in the name or on the account of his master or masters, or employer or employers, and shall fraudulently embezzle, secrete, or make away with the same, or any part thereof, every such offender shall be deemed to have feloniously stolen the same from his master or masters, employer or employers, for whose use or in whose name or names, or on whose account the same was or were delivered to, or taken into the possession of such servant, clerk, or other person so employed, although such money, goods, bond, bill, note, banker's draft, or other valuable security, was or were not otherwise received into the possession of his or their servant, clerk, or other person so employed, and every such offender, his adviser, procurer, aider, or abettor, being thereof lawfully convicted or attainted, shall be liable to be transported to such parts beyond the seas of his Majesty, by and with the advice of his Privy Council, shall appoint, for any term not exceeding 14 years, in the discretion of the court before whom such offender shall be convicted or adjudged. Section 507. Origin of the English Statute. The statute quoted in the preceding section was enacted in consequence of the decision in Bazley's case. In that case the chief teller of a bank received from a customer £137 for deposit to his credit. The teller gave the customer credit for the amount in his passbook, put £100 of the money in his own pocket and deposited the balance in the money drawer of the bank. All the judges agreed that it was not felony for the reason that the £100 was never in the possession of the bank, distinct from the possession of the defendant. Section 508. American Statutes. Statutes have been enacted in this country similar to the English statute. They vary more or less, however, and as penal statutes are strictly construed, the one involved in the particular case should be carefully studied. As a rule, these statutes are aimed at servants, clerks and agents who wrongfully appropriate to their own use property which they have received in the course of their employment for their master or principal, and also as trustees, who violate their trust by wrongfully appropriating property in their possession belonging to another. In several states a public officer who does not pay over to his successor all public monies in his hands at the end of his term, is guilty of embezzlement. Section 509. Scope of the statutes. The purpose of the embezzlement statutes is to supply a defect of the common law. In a Massachusetts case the court remarks, the statutes relating to embezzlement, both in this country and in England, had their origin in a design to supply a defect which was found to exist in the criminal law. By reason of nice and subtle distinctions, which the courts of law had recognized and sanctioned, it was difficult to reach and punish the fraudulent taking and appropriation of money and chattels by persons exercising certain trades and occupations, by virtue of which they held a relation of confidence or trust toward their employers or principals, and thereby became possessed of their property. In such cases the moral guilt was the same as if the offender had been guilty of an actual felonious taking, but in many cases he could not be convicted of larceny, because the property which had been fraudulently converted was lawfully in his possession by virtue of his employment, and there was not the technical taking or asportation which is essential to the proof of the crime of larceny. It follows, therefore, that common law larceny and statutory embezzlement do not overlap. In other words, the former cannot be the latter. This is Wharton's view, and it is also supported by the great weight of authority. And Bishop, however, takes the contrary view. Section 510. Receiving the property by virtue of the employment. The original English statute provided that the property fraudulently appropriated by the wrongdoer must have been received by him by virtue of his employment. Owing to confusion caused by this phrase, however, a later statute omits it, and provides instead that the chattel, money or valuable security shall be delivered to or received or taken into possession by him, for or in the name or on account of his master or employer. Thus the operator of a barge under the direction of its owner who hauled a load against the owner's express orders and kept the money was not guilty of embezzlement, because the money was not received by the defendant for or in the name or on account of his master or employer, as provided by statute. Nor was a miller in a county jail so guilty, whose duty was to grind grain when ordered to do so by the governor of the jail, receive the money for so doing and account for the same, and who ground grain without being ordered to do so, received the money for so doing and appropriated it to his own use. In this country, however, the courts very generally hold that the property must be received by the wrongdoer by virtue of his employment. The term, agent, or servant, as used in the statute, imports the correlative idea of a principal, or master, and implies employment, service, delegated authority, to do something in the name or stead of the principal and employment by virtue of which the money or property came into his possession. In this case the defendant was convicted of embezzling money which the indictment alleged came into his possession by virtue of his employment as servant or agent of one Rayner. The proof showed that the defendant, while acting in the capacity of mail carrier, fraudulently appropriated $395 which Rayner had sent by registered letter. The conviction was quashed because the defendant was not in the employ of Rayner, but in the employ of the United States government. Again, where a clerk collects money for his employer without authority, and fraudulently appropriates it, he is not guilty of embezzlement. Nor is a person, not a public officer, who receives public money by representing that he is entitled to receive it, guilty of embezzlement. It has been held, however, that an agent, who, after the expiration of his term, receives money belonging to his former employer and fraudulently converts it to his own use, is guilty of embezzlement. Section 511. The fraudulent intent. To constitute embezzlement, the property must be appropriated with fraudulent intent. Mere breach of contract is not sufficient. Thus where a lawyer, who also acted in the capacity of a loan and land agent, was convicted of embezzling $275 from a client, and the proof showed that the latter had given him $400 to loan for her, that he had loaned this for her and also $700 more which she gave him to loan for her, that he showed her a letter from a man who had 40 acres of land for sale, and requested her to let him have the money to buy the land, stating that he knew of a purchaser who would buy it at an advance, that she let him have $400 more to buy the land, saying that he might have the profit, that a month or so later she asked him for her money, and that he gave her $100 and a chattel mortgage for $25 which he owned, that several months later he conveyed to her 40 acres of land as security until he could pay her the balance. The conviction on appeal was quashed on the ground that the defendant did not entertain a fraudulent intent. Again, where a person retains property, under a bona fide claim of right, however untenable or frivolous his claim may be, he is not guilty of embezzlement for the reason that he does not entertain felonious intent. And mere neglect to turn over funds belonging to another does not constitute embezzlement for the same reason. where the funds are feloniously retained, however, demand that they be turned over is not essential. Section 512. Intent or offer to return property. The fact that one who intentionally and wrongfully appropriates the property of another lawfully in his possession, intends to subsequently return it, or make restitution to the owner, does not make his offense any the less embezzlement. After the crime of embezzlement has been consummated, an offer by the defendant to turn over the property to the owner will not purge him of the offense, nor will a settlement with the owner have this effect. Section 513. Ownership of the property in another. To constitute common law larceny, ownership of the property appropriated must be in another. And the embezzlement statutes of nearly all the states which undertake to define the crime provide that the subject of the offense must be the property of another. Moreover, this has been almost universally construed to mean that it must be wholly the property of another. As a result, a member of an ordinary partnership cannot, as a rule, be guilty of embezzling partnership property. It is to be observed, however, that where the statute is silent as to ownership of the property, and simply provides that an agent, etc., who embezzles or converts to his own use anything of value which shall come into his possession by virtue of his employment shall be guilty of embezzlement, this constitutes the test of the crime. Thus the cashier of an unincorporated banking association who was also a stockholder therein, who by virtue of his employment fraudulently converted to his own use assets of the association was held guilty of embezzlement. It has been well observed that considering the statutes are numerous, and in some respects diverse in their provisions, the practitioner should be cautious about coming to conclusions upon a question under the law of embezzlement, unless, when he examines a decision relied upon, he first sees whether the statute on which it was rendered is, in its terms, similar to the one of his own state. Section 514. Money paid or property delivered by mistake. As previously stated, the essential element of embezzlement is breach of trust. It follows, therefore, that where money is paid or property delivered by mistake, and the receiver of it wrongfully converts it to his own use, he is not guilty of this crime. In such case there is no breach of a trust or violation of a confidence intentionally reposed by one party and voluntarily assumed by another. A bank depositor, who was paid by mistake of the treasurer $230, instead of $130, the amount he had on deposit, and who, knowing of the mistake and knowing he was not entitled to the money which the treasurer afterward demanded of him, was not liable for embezzlement even though he appropriated the money to his own use with an intent to deprive the bank of its property.